Hello and welcome everyone. I am Santosh Baliga, and in this video I am going to discuss with you the topic of government company, which is defined under section 2 clause 45 of the Companies Act 2013. So please be with me for the next 20-25 minutes, and I am going to explain you everything about a government company as per the Companies Act. Okay, so first of all, what are the topics that I am going to cover? The topics in this video is going to be first the definition of government company, and I will also explain it with some scenarios which are there. The second topic will be whether a government company is same as a government department, and whether a government company's employee is a government employee. So it is going to be very interesting. I will also cover a couple of case laws over here, and finally we'll also look into the procedure of audit of the government's books of accounts. So these are the four broad topics that we will cover in next 20-25 minutes. So without wasting any time, let's start off with the definition of the government company under section 2 clause 45. See, what is the definition saying is that government company means any company in which not less than 51% of paid up share capital is held by the central government or by any state government or governments, or partly by the central government and partly by one or more of the state governments, and includes a company which is a subsidiary company of such government company. Okay, this is a definition. Let us now decode the definition one by one. Okay, so what is this definition telling us is that a government company is a company in which either the central government or the state government or state governments together, or partly by central government plus state government, holds not less than 51% of paid up share capital. Okay, so government company is a company in which the central government or combination of state governments or a combination of central government plus state government, okay, hold not less than 51% of the paid up share capital of the company. Now what do you mean by paid up share capital? Paid up share capital means it will include even the equity capital as well as the preference share capital. Okay, the combination of both shall be at least how much? 51%. I hope this is clear. Okay, now one more point is that in case if such company has issued special rights shares or differential voting right shares, then in that case, instead of paid up share capital, we will be looking at total voting rights. Okay, which means that the central government or state government or a combination of central government plus state government shall have at least how much? At least 51% of total voting rights in that particular company. Then it will be called as a government company. Is this clear? We will run through the scenarios. It will be very clear after understanding the scenarios. Okay, so now let us go into the scenarios first. First scenario is saying that, if you look at the scenarios, the first scenario is saying that XYZ company, central government is holding 25%, state government of Maharashtra is holding 25%, and state government of Rajasthan is holding 10%. Okay, and the rest of the shareholding is held with the public, which is 40%. Now understand over here that the name is showing as XYZ Limited. Just by reading the name, do you understand whether the company is a government company or not? No, we will not understand that. Hence, what we would require is that we would have to get into the shareholding pattern of the company, and in this shareholding pattern, if the government or a combination of governments are holding at least 51% of the total paid up share capital, then in that case we will call it as an government company. And in this scenario, in the first scenario, if you see, central government, state of Maharashtra, state government of Rajasthan is holding how much? Is holding 60%, and hence it is more than 51%, and hence it is an government company. Okay, the first scenario is clear. Second scenario is saying that central government has 25%, state government of Maharashtra has 25%, and public has 50%. So over here the threshold of at least 51% is not met, and hence XYZ company will not a government company, but just any other public company. Is this clear? Okay. Now in the third scenario, it is a very simple scenario where central government is owning 70% alone on its own, and public is owning 30%. So no state government is involved over here. This company will also be called as an government company. Okay. Now we go to the next scenario, which is XYZ Limited. Again, in this, state government of Maharashtra is holding 40%. Okay. State government of Tamil Nadu is holding 8%, and state government of Goa is holding 3%, which means how much? This comes to 51%. This comes to 51%, and the definition says not less than 51. That means 51 is the minimum which is required, and 51 minimum is met over here. Hence this company will also become an government company. Okay, so now the definition in terms of the threshold of 51% is clear to you in these four scenarios. Now once again I'll go to the definition, and we'll see the last part of the definition. If you see the last part of the definition, what is it saying? That includes a company which is a subsidiary company of such government company. Okay, so any subsidiary company of an existing government company will also be deemed as a government company. Let me show it to you with an scenario over here. Say XYZ company. Okay, this is XYZ company, which is a government company. Now we have established that it is a government company. Now there is another company which is PQR Limited. Okay, and if you go through the shareholding of PQR Limited, XYZ Limited holds 60% in this company, and public is holding 40% in this company. What does this mean? This means that XYZ company has a controlling interest of 60%, which means that XYZ Limited is a holding company, and PQR Limited is a subsidiary company of which company? XYZ company. XYZ company is already a government company. So a subsidiary of a government company will also be deemed to be a government company. Is this clear? Is the definition clear now? Okay, just read the definition once more. Means any company in which not less than 51% of the paid up share capital is held by the central government, or by state government or governments, or partly by central government, or partly by one or more of the state governments, and includes a company which is a subsidiary company of such government company. Very simple. Now you have understood all the scenarios. You have understood what is a government company, and also what I have explained to you. If the company has issued any kind of special right shares or DVRs, DVRs means differential voting right shares, then in that case, instead of paid up share capital, you will be using total voting power as the measure for calculation to understand whether 51% threshold has been met by the company or not. Okay, so this is the basic definition of government company. And move to the next point, that is whether a government company is a same as government department. See, many a times what happens is that many people say that a government company, like for example a company like ONGC, which is a government company, or a company like BHEL, which is a government company, and some more examples, SAIL, SAIL, which is a government company. Then we have गेल, गैस अथॉरिटी ऑफ इंडिया, ठीक है, गैस अथॉरिटी ऑफ इंडिया लिमिटेड, दैट इज ऑल्सो अ गवर्नमेंट कंपनी. मोस्टली देर आर मेनी पीपल हु सी गवर्नमेंट कंपनी सिनोनिमस विद गवर्नमेंट, okay, or government company synonymous with government department. But let me tell you over here that government company and government departments are two different things. See, a government company is a company which is incorporated under the Companies Act, and as per the characteristics of the company, we had learned that a company, once it is incorporated as a company under the Companies Act, it attains the feature of what? Feature of separate legal entity. And once there is a feature of separate legal entity, then the company is separate from its owner. So although the government may control the company, the government may have all the shares of the company, but still the company has its own legal distinct character, a separate legal entity. Company can own property in its own name, the company can enter into contracts in its own name, and hence there is a difference, there is a fine line between a government company and the government itself or the government's department itself. Okay, so a government company is not same as a government department. Okay, now what is a government department? Basically, government department is a part of the government itself, like a ministry or any income tax department. Okay, that is a department which is a part of the government itself. It is not a separate legal entity because it is not it does not have a character of a company, and it is not incorporated in the Companies Act. These departments or these ministries are basically a part of the government, and they come into existence by the Constitution of India, some of the articles of the Constitution of India, or through executive orders of the government itself. Okay, so some of the examples of government department are Ministry of Defense, Ministry of Finance, Income Tax Department. Okay, these are some of the examples of government department. So we have understood the concept over here, principle over here is that a government company is separate from a government department. That is clear. Also, one more difference is that the finance for the government departments, okay, that comes from the budget that the government will allocate, whereas it is not the same for a government company. For a government company, the finance comes from the share capital or the income from operations of that particular company. Okay, so finance comes from government budgets for government department, and finance comes from share capital plus income from operations for the government company. So have you understood this difference between a government company and a government department? One more point, one more very interesting point over here. The question now is that whether a government employee, okay, is the same as a government company employee. See, many a times what happens is that people say some person has got an employment in, say, State Bank of India, okay, State Bank of India, which is controlled by government majorly. So people say that अरे इसको तो सरकारी नौकरी लग गई है. But the point is whether it is a sarkari nokri, because he is not working in a government department, but he is working in a government funded, or you can say government controlled bank, where the government has more than 51%. That means it is a government company. State Bank of India is a government company. And whether the employee of such a company will become an employee of the department? No, it is not possible, and that has been proved by, or that has been given in several judgments of the Supreme Court also. We will go through the case laws just in a minute, but the concept is that employees of a government company are not government servants, but they are corporate employees of the government company. Okay, so they do not have all the rights which are there with the government servants, because the government servants are working as per the civil employment rules, whereas the government company employees are under the scope of their terms of employment, the contract of employment. Okay, this part is clear. So the third point is employees are government servants for government department, whereas employees are not government servants but corporate employees. Let us go through this. Let us understand this further with a couple of case laws. See, you have to, these are very important points over here, because the question nowadays will not come just on the definition. डेफिनेशन वाला क्वेश्चंस आने का टाइम अभी चला गया काफ़ी हद तक. काफ़ी सारे क्वेश्चंस उस पर पूछे गए हैं, एंड इट इज़ वेरी सिंपल. कभी कभी आ सकता है, बट you can expect the institutes to bring in questions which are deeper, like this kind of points that I am currently discussing with you. Okay, so let us get into the case law. One of the very famous landmark case in this is Sukhdev Singh versus Bhagat Ram 1975 case, pronounced by the Supreme Court over here. What was the issue? The issue was whether the employees of the government companies enjoy the same status as a government servants. We have just now discussed about this thing, that a government servant is different from a government company servant. Okay, government company is different from a government department. So let us understand what is the judgment of the Supreme Court on this particular issue. The Honorable Supreme Court held that statutory corporations and government companies are state under the Article 12 of the Constitution. But this means that the employees can enforce fundamental rights. Okay, this means that the employees of the government company can enforce fundamental rights, but their employees are not government servants. This is the Supreme Court in its judgment in the case of Sukhdev Singh versus Bhagat Ram 1975. Okay, it is very clearly pronouncing that their employees are not government servants. Their service is governed by the terms of their employment and not by civil service rules. Okay, so principal, what is the principal takeaway over here? Principal takeaway is that the government is a separate legal entity under the Companies Act and their employees are not government servants. So I hope now that after the discussion of the case law, this particular doubt, if it is there in your mind, that has been absolutely cleared. Okay, there are some other supporting case laws which also say that a government company or a statutory corporation also is a part of the definition of state under Article 12. Hence, the employees of the government companies or statutory corporations can approach the court for the fundamental rights that has to be protected, but they are not the government servants of the government of India. Okay, they will have under Article 12 the protection to fight for their fundamental rights, like the fundamental right in terms of equality under the Article 14 or fair treatment under Article 16. One more case law over here which I am speaking about is R.D. Shetty versus International Airport Authority of India. This is a 1979 Supreme Court case. So this is one more case which is the case law which is there. Again, the government companies come under the scope of the state under Article 12 of the Constitution. This is what the Supreme Court has said over here. But remember, Supreme Court in Sukhdev Singh and versus Bhagat Singh has also said that it is a state, but the employees will not be termed as an or not be seen as an government servant. Okay, they are corporate employees. Okay, so this was the part of the government company and government department and government employee and government companies employees. Okay, I hope this was interesting for all of you. The last part of this particular video is audit of the government company. How will the audit of a government company happen? See, the audit of the government company is done by the CAG. CAG means Controller and Auditor General of India. Okay, so CAG means Controller and Auditor General of India. So all the public companies or government companies or public departments, wherever the public money is used, to ensure that there is no misuse of the public money, CAG is the only authority which is given under the Constitution the powers to audit such particular companies. Okay, so the CAG in case of government company will appoint auditors from its panel of auditors, which will be basically a practicing chartered accountant or a firm of practicing chartered accountants. So over here I won't want to give you a connection of section 139 which covers the appointment, the provisions relating to appointment of auditor for a government company. Over there it is very clearly mentioned that CAG will appoint the first auditor within 60 days of the registration of the company. So any new government company comes into place, then within 60 days of its registration, the CAG's responsibility is to ensure that there is an auditor which is appointed. And in the subsequent years after the first year, CAG shall appoint within 180 days from the commencement of the financial year. Okay, so you have understood that who conducts the audit for a government company, who appoints the auditors, under which section, section 139, within what timeline, if it is the first auditor, that is the first year of the company, within 60 days of the registration, and the subsequent years it will be within 180 days of the commencement of the commencement of the financial year. Commencement of the financial year means what? See, financial year commences in April, so from here it will be within 180 days, which is basically 30th of September. So within 30th of September, that is 180 days, the CAG will appoint whom? CAG will appoint an auditor from its panel of auditors. Okay. Now coming back to the audit of the government company, the CAG can direct such auditors the manner in which to conduct such audit of the government company. The auditor shall submit the audit report to the CAG. So the auditor appointed will complete its audit procedure and give its audit report to the CAG. Okay, and include that particular report shall include if there is any directions given by the CAG and whatever impact of such directions or such directions are on the accounts and financial statement of the company. So it shall include the directions of the CAG, the action taken thereon, and its impact on the accounts and financial statement of the company. Okay, so what have we understood? Government company, audit is done by CAG. CAG appoints the auditor. Auditor does the audit and submits the audit report to whom? To the CAG. Okay, and the CAG then within 60 days of receipt of such an audit report may again conduct an supplemental audit. Okay, separate audit again he can conduct himself, or he can appoint any other auditor to do that, and supplemental audit report can also be attached to the main audit report. The CAG can give comments on both the audit report and the supplemental audit report, and such audit report plus supplemental audit report, if any, has to be placed by the company in the AGM, and it has to be sent to all the members or all the persons who are entitled to receive the copy of the audited financial statement. So let us go through this. That the CAG may conduct supplemental audit within how many days? Within how many days? Within 60 days of the receipt of the audit report. And give his comments on the audit report and such supplemental report. Such supplemental report and audit report, once it is ready, the company will send the audit report with comments to every such person entitled to copies of the audit financial statement under section 136 subsection 1. See, section 136 subsection 1, I have already created a video on this and it is there on the channel. Go and check that video. That video gives you a very detailed explanation on section 136 subsection 1 as to who is entitled to receive the copy of the audited financial statements. Okay, and place the audited financial statement, the audit report, the supplemental audit report, the comments of the CAG within CAG in the annual general meeting of the company. Now once the annual general meeting of the company is done and the financial statements are approved after checking the audit report and everything by the shareholders, within 3 months of the AGM, within how many months? Within 3 months of the AGM, the CAG will lay before the both houses of parliament, in case the shareholding is held by the central government itself, or in case the shareholding is held by the state governments also, then it has to be also laid down in the both houses of state legislature of such state government. Okay, so the audit report plus the supplemental audit report, a copy of that has to be placed in the both houses of parliament if the shareholding is held by the central government, even if it is partly. Okay, both houses of parliament means what? Lok Sabha and Rajya Sabha. Okay, and it has to be, if the state government has a stake in the company share, or the state government is holding any shares in the company, then it has to be also be laid down in the both houses of state legislature, which is actually a legislative assembly and legislative council of the state government. Okay, so this part is also clear. The audit part is clear. So we have understood government company completely. The definition, whether government company and government department is the same? No. Whether government company employee and the government servant is the same? No. Whether government company is a state? Yes. And fundamental rights are available to the employees? Yes. The audit of the government company is done by CAG. It appoints the auditors from its panel, and the appointment of auditors is covered under the provisions of section 139. The auditor does the audit and gives the audit report to the CAG. CAG can conduct supplemental audit of the same. The supplemental audit report plus CAG's comments plus the audit report is given to the persons who are entitled to receive the copy of the audited financial statement under section 136(1). Then it is placed in the AGM. After the AGM, within 3 months, it has to be laid down in the both houses of parliament or both houses of state legislature, as the case may be, and that's it. That's the government company for you. I hope you have understood everything. The scenarios also were very, very clear. That's it from me in this particular video. I'll see you soon in some other video. But if you have found this video as very, very useful for you, if you have understood the government company completely, then please give this particular video a like and share it with your friends, and subscribe to the channel so that it gives me more motivation to come up with more such videos for you very soon. Thanks a lot. Bye for now.